medical statements to that effect. I'm relying on what I've been advised by his co-accused, who is the first accused.
You are relying
on the first accused person, and also from the relatives of my client who are in the know. But I have no reason not to believe that that is the correct position given the state of affairs. When I last spoke with him, it was before that development of the 7-day, but he was telling me that they had, the government medical doctor had then come in late. I think from the last time we had an adjournment, they had not seen that medical doctor, and he was still waiting at that time. So we applied that the matter be postponed. Possibly a 2-week postponement would meet the circumstances. It would be difficult for the diary of the court if we then stick to if we say 7 days, then the next available date would be perhaps on Friday. But it might be necessary for us to monitor the medical situation of the second accused. We had discussed that with the state. We were thinking that it will proceed by way of consent, that the matter, if it is fine by the court, that the matter be postponed. We are in a difficult situation. There is nothing that can happen until we are able to ascertain the situation of the second accused. That would be the brief application.
So, do you have instructions from the second accused person to seek the postponement?
My Lord, yes, we have these instructions, meaning we are fully mandated to do what we are doing at the moment.
I know. But I'm saying, obviously, my understanding is that you will have instructions from him to seek a postponement and the basis thereof, and the period that you would require, and the basis thereof as well. I'm sure you understand what I'm driving at. Probably he wants to be here tomorrow. Probably he wants to be here in the afternoon. I'm simply trying to say, I'm not trying to get involved in your relationship with your client, but certainly I would expect that you would have specific instructions from him regarding whether, his condition and when he's likely to be available. I just expect that the application would be from an informed position. I think that's what I'm failing to say. It would have to be an application from an informed position. But if it is an application based on what you have heard from the first accused person, or perhaps from relatives, but you have no, perhaps you even say that you do not have a medical report. Perhaps it's there, it's existing somewhere.
My Lord and the learned assessors, we have pressed an application before the court. We are standing by the submissions I have made to the court. We are seeking a postponement, and we would respectively submit that there will be at least a 2-week postponement. That is all I can say in response to what my Lord has said.
Mr. Mpofu.
My Lord, Honorable Assessors, the second accused person was asked by this honorable court to be here today. He is in the custody of prisons. Prisons is the one which is supposed to come and explain why the accused person is not in attendance. Not Professor Madu. I mean, Mr. Madu. Mr. Madu has no any responsibility in securing his attendance in court. So what is supposed to happen is that prison is supposed to explain why the second accused person was not brought to court as instructed by the court, so that the court is well informed on why he was left behind. Please. But otherwise, all of us will be merely speculating in the absence of a report from prisons in whose custody the second accused person is being kept. My learned colleague has just said he was informed by the first accused person, but it is not the responsibility of another inmate to explain the absence of an accused person who was specifically instructed to be here today before the court. So perhaps the officer in charge of prison is the one who is best suited to explain to the court why the second accused person was left behind.
My Lord, with the leave of the court, we respectively disagree with that approach and that submission. My learned friend represents the state. It's not the prisons. They are not supposed to come here at all. We have counsel, we have the court and the two parties who are here. There is no procedure for what my learned friend is saying. The state must indicate if he has to go and consult them, he can go and consult them. But the position as we stand is that the second accused is not present. We represent him as his lawyers. We have made an application for postponement based on our understanding of what is happening, and I think we are entitled to do that. If my learned friend has no information as to what is going on, then that will be their problem. They ought to represent the state. That's our submission. It will be improper for the court to go that far. And also it will undermine the interests of the second accused person. He is not here, he is not feeling well, and I think this whole process ought to be handled in accordance with the law.
Which law?
The law of fair trial.
Meaning what? I'm saying that's generally the principle.
The principle.
Which law should govern the situation that we are in? What's the legal framework?
I would refer to the common law, my lord. The procedural position is that the court consists of three parties. The court and the two parties, they are represented by counsel, the state and the accused persons. And that the state counsel is responsible for speaking on behalf of the state that is supposed to bring the person here.
Yes, but he has said he wants prison to explain. He's representing the state. And he has said he wants prisons to explain. Why then should you be opposed to that? You are saying that he's responsible as the representative. That is the approach that he wants. Why should you resist that?
We don't believe that there is any basis for that.
But that's how he wants to procure the attendance of your client as the state. He wants to the state to the prisons to explain to the court why he expected prisons to bring, and he says when they are not here, he wants prisons to explain in an open court why they are accused and what is wrong with that.
My lord, I think if you want detailed submissions, we'll be able to make these submissions. We object to a situation. If you want to make an application for prisons to be brought here, we are not in a trial. We are really at the interlocutory stage. Are we proceeding or not proceeding? There's no room at that stage for the participation of other parties. If you want prisons to come here, prisons would have to be sworn in as witnesses. We have to cross-examine them, and so we don't know such a procedure. It doesn't exist. The court must be guided by the parties who are present. My lord, I'm not standing on my feet. I will not be able to give you the authorities but I insist and respectively submit that it will be completely out of line for us at this stage to start leading evidence from prisons. It is simply an administrative aspect. The lawyers for the state would indicate they have to do the private investigations. If they believe that prisons...
No, it's not anything private. I have come here, we have all come here expecting the accused persons to be here. And it is the court which wants to know. We cannot be involved in any private investigations as a court.
But the court would be involved in private investigations if the court has to hear from prison itself. The court must not hear from prison in respect of the presence, unless the state is alleging something. It's administrative, my lord. The court would have crossed the floor The state must come and advise the court if it is not satisfied of his absence. Let those issues be dealt with administratively before. This is how we submit it. We don't need to get into further discussions with the court. I think unless the court, we don't want to be seen like we are disagreeing with you. But my little friend is out of line. The court can adjourn. We can have a discussion with him. He has to find, if he wants to find out something, he can find out, but not to bring prisons here.
Thank you. Who is in charge of prisons here? In this court? Your name? What is your rank? Very well. We will require the official in charge of prisons at court to appear in court in the next 5 minutes. Yes, I'm sure you know why we are calling me. We want to know why the second accused person is not in court. Yes. The court will adjourn.
If it pleases this Honorable Court, my Lord, to continue hearing the matter of State versus Mpofu and one another.
Thank you. Yes. I see, Inspector. Your name?
PCO Chikoto.
PCO stands for what?
Principal Correction Officer.
You are the officer in charge at court today.
Yes.
Yes. We are dealing with the matter involving the state versus Moses Mpofu and Mike Chimombe. Yes. As you can see, we have got only the first accused person, Mr. Mpofu. Am I correct? Yes. Mike Mpofu. And the second accused person is not in attendance. We would require an explanation from you as to why the second accused person, whom we believe is in custody, why he is not here.
Yes, my lord. Moses Mike Chimombe is not really feeling well, so he's to see his doctor today.
You are aware of your responsibility to bring him to court as prisoners? Were you aware of your responsibility to bring Mike Chimombe to court today?
Yes, my lord.
And so why did you not offer an explanation at your own initiative of his absence?
I've been told in the morning that the court is aware of that. So I thought maybe for us.
How would the court be aware when he's in your custody?
My lord.
You don't need to consult the first accused person. I'm talking to you as prisoners. He is in custody and you've got a duty to bring him to court. And I'm simply asking you why you did not, well, were aware of your responsibility to bring him before the court, and that you had not brought him to court. Why did you not, advise the court of that situation, of your own initiative? This is a statutory obligation. That's why you exist, isn't it? As prisons, that's your role, isn't it? Particularly, with respect to those accused persons, that you're supposed to bring them to court when they are required. And I thought you would have expected, you were expected then to, if you are unable to bring for any reason an accused person who is required for trial, to explain to the court, perhaps through the prosecutor or through counsel here who is representing him. Whichever route you were going to take, that was entirely up to you, but do I have to remind you of that responsibility?
My lord, I was not, in fact, I've been told that Mike Chimombe is not feeling well. Today is this day that he is going to see his doctor. Mm-hmm. That is over that.
Yes. So what do you want the court to do?
Maybe the court may request him for tomorrow, my worship, my lord.
We don't have to request him. We made the order that this would be his trial date. That's enough. Do we request prisons? Do we request prisons to bring an accused person? It's an order, isn't it? Do we have to make a request to you to bring an accused person?
Maybe if we may come tomorrow, my lord, since he is going to see his doctor today.
Very well. We will stand the matter down to 2 p.m. or so that you place before this court an official document as to why the second accused person is not in court, and what should happen, because the court has already ordered that he should be here today. And it is not up to you, to keep him at prisons when he's required at court. He must be excused by the court if there's good reason for him to be excused by the court. And I want you to communicate that the court does not apply to you, does not make any request to you to bring, it orders you to bring an accused person to court. And obviously, if you disobey a court order, the consequences are well known. You are aware of that. So my order is that he should be here at 2 p.m. And if he's not here, we require an explanation from prisons as to why he's not in attendance. You understand?
Thank you, my lord.
My lord, if I may advise the court that we have a Supreme Court hearing at 2:30 today in respect of the same accused person, the bail appeal, which was postponed to 2:30 today. So we should be at the Supreme Court at least by 2. They expect us to have logged in. It's a virtual hearing.
It is true, my lord, that we are at the Supreme Court, but however, the state is being represented by 2 counsels, and accused number 2 is represented by 3 counsels. Not all of us are going to make representation. This court can still function for the purposes of ascertaining why the second accused person is not in attendance. Mr. Masuku can be here and I go to Supreme Court. I'm sure the defense with 3 counsels can similarly make such arrangements as well. I don't think 3 counsels will be making representation at the Supreme Court.
My lord, if I may advise the court that all 3 are required at the Supreme Court, will be arguing the matter all 3. There is no provision for another person to be here. But also that in terms of the rules, although the accused person need not be present at the Supreme Court, I think it's only fair that we should not have 2 matters proceeding at the same time in respect of the same accused person. We would plead with the court to take that into account.
I don't know. All we are requiring is for the accused person to appear before the court because he was ordered to appear. We can't overlook that. It's a requirement. He was ordered to appear, he must appear. The fact that he's coming from custody does not change the position that he must appear before the court.
Yes, I hear.
And all I've said is that because both of you agree that he's in prisons, I've simply ordered prisons to bring him to court. You don't even have to be here.
Well, if
it's for the court to see him. Is that what's wrong with it?
My Lord, no, we have no issues. If you are just seeing him, if not a trial, it's something else. But if it is in pursuance of a trial, then the accused person is supposed to be represented by us in terms of the law. He has a right to legal representation. And that because of that constitutional right to legal representation, it cannot be achieved when we are again appearing in the Supreme Court. And we are putting it just for the record so that the court appreciates that. We also say that in terms of the law, it would not be appropriate for the court to relate to the second accused person in the absence of his lawyers, whatever that function would be, because there would be no provision for that in the Criminal Procedure and Evidence Act.
Provision for what?
For a court sitting to see an accused person, if it is not a sitting of a trial court. Because this court can only sit as a trial court at all times. It cannot sit in any other capacity. So we are saying that if the trial has to proceed, because what the order, our understanding of the order is that the trial...
So you're saying I should rescind the order?
I think there is room for you to correct an order that was made by an oversight. The oversight being that when it was not put to the court that at the time that you are indicating, there is another court, which is a superior court to this court. And we need to bring that to your attention. You certainly, with respect, ought to rescind the order in the light of the information that has come. The doctrine of functus officio would not apply where an order is made manifestly on the basis of an error or on the basis that there is a fact that is not made to your attention.
Very well. I'm unable to do that. My directive to prison stands. If for any good reason you are not available, the court will be able to deal with that situation when it arises. You have explained that you'll be in the Supreme Court. If you consider that all of you have to be in the Supreme Court and the accused person will be here without counsel, the court will deal with that situation in a manner which is fair. This is a directive that I have given to prisons. It's possible they will bring him. It's possible they will bring an explanation. We don't know. But the court is always fair. The court is always aware of his right to legal representation. All those things, I'm sure it's assumed that the court knows all that. And if whatever situation arises, the court will deal it appropriately.
Yes, the court pleases.
Yes.
Yes, pardon me, my lord. I stand to stand in and maybe just seek clarity from the court with respect to the first accused person, whether or not he's required to attend.
I think naturally he has to be there for continuation of the proceedings at 2 p.m. Unless you are thinking of something that
no, I wanted to know whether or not I must make other commitments. So not that
I don't know. You see, that's the situation that we have. These things just happen in court. That's the problem I'm having. I've complained several times that it's not appropriate to take the court by surprise. This situation was known. We sat late because this court was being used by the judge who was presiding over bails. That was opportunity for counsel to approach me in chambers and advise me of this. It didn't happen. I only learned of this development when I'm tired of complaining. You can do as you please, but it's not right. You know it, don't you?
My lord, I would have accepted that my brother from the States. I've
learned etiquette from counsel, particularly those who appear in the Supreme Court. We benefit a lot from your experience from the Supreme Court. And I know that you know that I was sitting in the office, in my chambers, expecting to start the trial. And when I'm invited to court, it's because counsel are ready, all of you. If for any reason any one of you believes that we won't be ready, you have the duty to approach me and advise me in time. It doesn't have to be the state. It doesn't have to. All of you have the duty to explain if the court will not be ready. So if I don't receive any communication from counsel, I expect that the court is ready. But very often I just get this information when I come here to see it. So what can I do?
A pre-trial meeting between counsels would have resolved it. I would have expected maybe.
No, but at least I should know. I should know. As the judge presiding, I expect to start at 10. Administration told me that court is not ready because it's being used by another court. She has a duty to advise the court, the assessors, and counsel. So when she advises me, I assume that she has advised everybody, isn't it? And when, if counsel for any reason are not ready, they also have the duty to advise the court. It was, any deliberations amongst yourselves was not going to, deal with the situation without advising the judge and the assessors. We need to know.
Yeah, it would have been neater, my lord.
Yes, I've said this before. It's neater to advise us in advance. We sometimes we can manage these things in a neater way. But as I say, I don't know what's going to happen at 2 o'clock. We will see what the situation will be. But I have encouraged you in chambers. I've done that. I've said, let us, as much as possible, be courteous with each other in dealing with this matter. Yeah, we are all part of the same system, and we must, as much as possible, protect its integrity.
Thank you very much.
I was just thinking, we acceded to the request to live stream these proceedings. What we intended to live stream were trial proceedings. We have not made any progress in that regard since October. Do we still need live streaming?
I think it's an important question that may need consideration, my lord.
Therefore, I throw it to you. Maybe it will be required for the purpose of the trial, when the trial progresses. We have started the trial, but we have not gone into the merits. And I'm sure that is what the media requested to live stream. But it's entirely up to you. I'm just presiding. You are the parties involved. You decide on what you want. And obviously, we will consider the position you take and see whether we, depending on the guidance that you give us, we'll decide on it. I'm just thinking that perhaps we have not really made much progress on the merits, and the request that I had was to live stream the trial proceedings, and that has not happened. Perhaps how many months later? 5 months later. Yeah, so it's entirely, you guide me, you deliberate that as counsel, and then you may decide what to do, whether you want. You can the ways of communication. You can either communicate your position in chambers, or you can opt to do so in an open court. It's entirely up to you.
We'll take further instructions.
Yes, states, I'm sure you are in agreement with that approach.
Yes, my lord. And the state wishes its witnesses to be de-warned until the situation is clear. They have been religiously coming. They are not a problem in attending court. But as things stand, it becomes difficult. But however, the state can secure any of them at short notice. Yes.
Yeah, sure.
At short notice. Should a trial date be availed in earnest? Also, can you call all the state witnesses in the state reserve for Mpofu and Chimombe? You come in.
How many witnesses do you have today?
There are five. Today with blind and five. All of them, they are not a problem in securing their attendance. In a short notice, the state can secure their presence in court if they are due warning in the meantime.
No. Very well, witnesses, I won't need to record your names because we are about to excuse you. The second accused person is not in attendance. We are advised that he is still unwell. So we have to excuse you, and I'm advised by the State Council that he will be able to communicate with you. He will not have any difficulties in communicating with you when you are quiet, and even at short notice. And I think we believe that because you have not been able to testify and you have been coming to court, we have no reason to believe that you will not come to court when required. But because of this uncertainty, we don't know what the condition the second accused person is and how long he requires and so on. The state has suggested that we can excuse you, and so we are de-warning you, and then you can go back to work and do whatever, and then wait for the State Council to advise you as when you will be required to attend. So now you are free to make your engagements wherever you are, but in liaison with the state, as long as the engagements are not taking you too far away from the court. You understand? Is there anything that you need further explanation on? I'm simply saying you are still required at court, and it may well be at short notice, but it won't be unreasonable notice. Okay. But I'm encouraging you to always bear in mind that you may be required at short notice to give evidence. So whatever engagements you are going to commit to must be such that they won't really make it difficult for the court to reach you. I think that's, so that we have a win-win situation. We free you to do your work, but we must be able to find you when we require you. So for now, you are free to go. Don't come back until the State Council gets in touch with you, either through telephone or the usual subpoenas that you were served with. Thank you very much. Very well. So prisons, we expect we expect to hear from you at 2 o'clock. Yes. It's normally 2:30, isn't it? Yeah, 2:30. 2:30. Yeah, just be precise. The court will adjourn.